Good evening, ladies and germs. Hope everyone's doing well tonight. Sorry, I say this every single time. Sorry we're getting started about 5 minutes late. I'm not even going to make an excuse this time. Let's just pretend I'm always going to be 5 minutes late to start our 7:30 webinar. Welcome, everyone. Tonight is going to be interesting. Unless I get a whole bunch of questions from our not-so-huge audience most of the time, I'm going to devote the entire hour to a subject matter that if you haven't lived in a hole for the last couple of years, you've probably heard about once or twice on the news, scrolling down through Facebook, shaken baby syndrome. If you've never heard of that before, Google it real quick before we get started here. And I'm going to devote the entire hour to it because it's not only a hot button issue right now, but it's responsible for the two individuals in my 15 years of legal practice that I truly and honestly believe are currently incarcerated for killing their babies, by the way, and they're not guilty. And so we're going to talk a little bit about what it is, a little bit about how it started. We're going to talk a lot about how it has become essentially a medical theory as black and white as diagnosing cancer, but it's not. And then we're going to talk about how to fix it. And that's the most important point that we're going to try to make tonight. Not how to fix it the way it gets fixed right now, which is a group of great people like the Innocence Project gets involved, and some good lawyers that really care get involved and win on post-conviction relief or writs of habeas corpus. Not fix it like that. Okay, we're going to talk about how to fix it foundation-wise, right? And really that's by convincing one group of people of what those of us that have tried any shaken baby cases know, and that it's garbage. It's junk science. It's not like any other medical theory. They didn't develop it like any other medical theory. They don't use it like any other medical theory. I wanted to wait till the end of the webinar to give this fact, but I'm going to give it right now because I want to get everyone's attention. The man who made the term up, defined the term, and literally invented shaken baby syndrome testifies for the defense now. I say that he was 102 years old the last time I saw him in a video on YouTube testifying or reviewing records to testify for a defendant in a shaken baby case. And the reason he testifies for the defense is because he is aghast at what has become of shaken baby syndrome. And that's what we're going to start with is what is it? What does it become? Really, the only context in which you're ever going to hear or know about shaken baby syndrome is criminal court. And shaken baby syndrome is a theory that what's called the triad of symptoms. And the triad of symptoms is all of these internal head injuries. So the big ones are subdural hematomas and retinal damage.
Retinal hemorrhaging.
Right, retinal hemorrhaging. The third one is a swollen brain, and the swollen brain situation can happen like right after death. So that's not the most defining of the two, but the retinal hemorrhaging, the retinal damage, and the subdural hematomas. Those are the big ones. And a subdural hematoma is, I'm going to explain this basic. This takes days for these experts to explain on a witness stand. I'm going to knock it out here in about 5 seconds. So you got your brain inside your skull, right? This is my lawyer medicine. You have your brain inside your skull, and laying on top of your brain is a wet rag. That wet rag is called the dura. And then on top of the wet rag, of course, the wet rag is your skull, your bones. And so a subdural hematoma is a hematoma, which is a bruise or blood coming out somewhere, a mass of blood, in between the wet rag and your brain, but not in between the wet rag and your skull. That's a subdural hematoma. So you say a subdural hematoma, a lot of lay people think if you smack someone in the head, it'll give them a subdural hematoma. It will, but it'll also put a hematoma where you can see it, a bruise on the head, which is not a subdural hematoma. But most of these cases that become shaken baby cases are cases where the pathology of the victim, so the dead baby, after death is found to have subdural hematomas, retinal hemorrhaging, and in most cases, no other physical damage. So no bruising, no finger marks, no neck injuries. That's the one we're going to get into a lot, people, because I'm just going to tell you right now, I don't know how you could possibly shake a 2-month-old baby to death without hurting its neck. Now, the factual theories on that, by the way, are you could softly throw a baby up and down on a bed 50 times. Because that's how people kill babies in rage killings, which is the only way these are alleged to have happened. So, starting with that premise, you know, I want to be a little objective right now, okay? So let's start out with, I don't blame the prosecutors that are trying these cases, the medical professionals that are testifying in these cases, the police officers that are investigating these cases. It's really a combination of everything working together in a lot of groups of people that aren't going to go outside the box very often, all coming together in an adversarial system and a desire to win that creates what happens in these shaken baby cases. And I want to be really clear about what happens in these cases. Two sets of medical professionals come in to testify for the state: emergency room pediatricians and forensic pathologists. Emergency room emergency room doctors come in and testify that throughout the day, while the child was in the emergency room and they were trying to save his or her life, they thought about, 1,500 different theories, one of which was abusive head trauma, shaken baby syndrome. And the reason they did that is because they're doing it in a diagnostic emergency room context. So they're throwing everything up against the wall to try to save a life. But when they testify at trial to the jury, they testify as though they made any effort at all to find out what happened, how the child died. And the reality is they didn't. They tried that day to find out what they could do and what they could know about what was going on to try to save the child's life. But after that day, because they're emergency room pediatricians and had to deal with the next emergency, none of them made any effort, investigated, talked about the pathology, read the autopsy report. None of the doctors who testified for the state that they saw the child, they watched the child die, and they know what happened. None of them testify that they didn't really investigate anything about how the child died. All they did was investigate what was going on from a context of trying to save the child's life. Then you combine that with a forensic pathologist who testifies, I love these, I'm not a causation expert, so I can't tell the jury how the pathology happened. But then, about an hour later in the testimony you always get into. But I can tell you that there are very few ways that a child could present like this without abuse being indicated. So that's problem number one with this theory, and that is the state never has to stand up and say, factually, this is what happened. They'll say things like, well, sure, you could create these injuries by throwing a baby up and down on a bed 50 times softly. But they don't say this is what happened in the case, because I personally think they can't put together a fact pattern wherein you end up with subdural hematomas and no neck damage with a 2-month-old. But when you put one doctor on the stand in an emergency room context to a jury saying, yeah, we thought it might be shaken baby, and then you put another doctor on the stand, a post-mortem examiner with an autopsy report to say, well, based on all the literature and everything I'm told as a doctor, there aren't a lot of ways that a child could present with just the triad of symptoms and it not be abuse. I beg to differ. and there are a lot of ways, there are a lot of organic ways that present as the triad of symptoms. Glutaric aciduria and glutaric acidemia. I could go on for the next 15 minutes and give you examples of things in the last 15 years we have found that medical science has uncovered that organically mimic the triad of symptoms. It's amazing. And when these doctors testify, they're so sure that there isn't anything else out there, that there couldn't possibly be a medical theory that we don't know right now that presents as the triad of symptoms that a child died of. Now, in 2005, a doctor would have told you that glutaric aciduria doesn't exist and mimic the triad of symptoms, because that's when they found out that it did. So, again, it's very presumptive, I think, of the medical profession to not admit in cases like this that, yes, we are constantly uncovering other ways, very rare and unique ways, but other medical ways that these children could die and present this way pathologically, instead of really not knowing and just saying, yeah, well, we don't know, so, yep. Because the consequences here, we're not talking about civil punishment. We're not talking about money judgments. We're not talking about, we're not even just talking about loss of freedom. We're talking about being labeled a baby killer. Because there's obviously no other way that you get involved in a shaken baby case unless there's a dead baby. So that's problem number one with it. I mean, just from the jump, everybody loses in a shaken baby case because the baby's dead. The families are against each other. One family, the person who's not charged usually feels some sense of guilt. Over time, going through these cases, if you're actually involved in it, I don't care which side you're on. By the end of it, if you do not admit that you have doubts about whether or not the child could have died that way, you're lying. And That's the professionals on both sides of it. And so one family member usually has to start examining, well, then how did this baby die? Is it something I did? And they start feeling guilty. And how do you deal with that guilt? Well, you start pointing fingers at someone else. It's a hell of a lot easier to say that abusive baby killer killed my baby than it is to think that, I don't know, smoking or drinking all during my pregnancy may have affected the child. And the reality is there's facts all about all kinds of things that when you get to trial in the context of what a jury can and can't hear, they're not allowed to hear a lot. But what are they allowed to hear in these shaken baby cases? So you hear an emergency room pediatrician testifying as though they were a doctor that investigated the cause of the child's death, and that's not true. You hear a forensic pathologist say there aren't a lot of ways that a child could present pathologically after death with the triad of symptoms, but also testifying that they're not a causation expert. Then you throw in the other parent, who of course now has been groomed over the last year and a half preceding trial to look at all these other things that the defense attorney might throw at them that they may have caused the death, and so they're out for blood themselves. They don't want people to start pointing the finger at them. They've got a dead child, so they have to be this, we have to fight the good fight. And that's how they set it all up. And then you have a jury full of people who, I've heard this statistic a lot of times, and I'm not a big stats guy, but it's something over 95% of cases, doesn't matter the charge, involving the death of an infant are convictions. Facts don't matter. There's a dead baby. And trust me, I have lived that before. And it's probably not a good time for a good Shoemaker story. So the first shaken baby case I did, the first one. So I know that I'm amongst a select few attorneys. This is not a good select few, but a select few attorneys in this country that have tried and lost more than one of these cases. And there's a reason for that. They are a siege of awfulness. And the problem is, for all the good attorneys out there, only the ones that are maybe independently wealthy or can take these cases on. It doesn't really matter what type of retainer you get. Your life's going to be under siege. Your life, with the family members, with people. Anybody that's done criminal defense is going to tell you having an innocent client is the worst thing in the world. My goodness, you can pull a rabbit out of a hat for 100 guilty clients, but that trial for someone who you think is innocent is a tough one. Then when you involve a dead baby in it, the first one that I did back in 2006, the doctors, the doctors involved in the case, same type as emergency room pediatrician, and in that case they brought in an expert witness, a child abuse expert, who reviewed the medical records and reviewed the autopsy report and came to the conclusion that the child had to have died from abuse. Now this was a shaken baby expert. And shaken baby experts are paid to say shaken baby is the only way that this could have happened. But in that case, the doctor didn't. I guess the state didn't prep him very well, because he admitted at the end of his testimony that the injuries to this child were so bad that they had to have occurred within 15 minutes of the 911 call. What the doctor didn't know when he was testifying, and probably should have, is that the only 10 minutes that my client, the defendant, was ever alone with that baby was about an hour and a half earlier. So, I remember it being reiterated on cross-examination with the doctor by a very, very close friend of mine who was the trial attorney for that case. And I sat second chair, and the cross-examination hammered this doctor home with, it had to have happened between 11:15 and 11:30. Hammered it home. And I remember that night thinking, that's it. My 9-year-old son could understand that doctor, the state's expert, just exonerated the defendant. So that ends up going to the jury, that case, and we're standing there with this very young man, 19 years old. He was dating a 17-year-old mother. They went back to her house. They were alone in the basement with the baby. She went upstairs and took a shower for 10 minutes, during of which he was on the phone with his father the whole time, phone record showed. Nobody heard anything weird. She came back downstairs. They smoked a cigarette. They watched some TV. I think they even had relations right there, and the child, when the mom goes and checks on it about an hour and a half later, is cold. She calls 911. The triad of symptoms is there. The child looks pristine, clean on the outside. And so, sorry, I'm reading some of the comments now, which I have to do on another screen. Come on, Facebook. Let's get it together here. Where was I? This 19-year-old kid goes to the police station 2 days later. Goes to the police station 2 days after this child's death and sits down to try to help the police find out what happened. And he is interrogated for 6 hours and 45 minutes, during which 183 times he says, "I don't know what happened," or "I didn't do anything." And then when they're talking to him about bouncing the baby up and down on his knee and maybe the baby falling, he says, and I quote, "I would never have meant to hurt that baby." And that, ladies and gentlemen, became his confession. From that point forward, he's never been outside of a jail cell. He was arrested at that moment, and as soon as everything started going down and they said, "You just admitted to killing the baby," he said, "I want a lawyer." And this is my favorite part of that trial. I've talked about this one before, how the judge admonishes a jury and just reminds them of something awful the state just did. In that case, the state kept asking the detective, "So after you accused him of killing the child and admitting to it, what did he do next?" "Well, he asked for a lawyer." You can't adversely comment on an exercise of someone's constitutional right. And prosecutors know that. They're not supposed to ask that question in any event. What this case ends up with, it goes to the jury, and the jury comes back with the verdict sheet. First degree murder, not guilty. Second degree murder, not guilty. Voluntary manslaughter, not guilty. And I don't know if you've ever heard the term knees buckled. I've heard that term a lot, and I've witnessed it one time in my life, and it was when you're not guilty of voluntary manslaughter, this 19-year-old kid's knees buckled because it was over. There's no way anybody was alleging this was an involuntary manslaughter case. Involuntary manslaughter, guilty. And then, underneath all of those on the verdict sheet, first-degree child abuse, which, by the way, is the same crime as first-degree murder in the state of Maryland, just involving a child, guilty. And so the involuntary manslaughter, by the way, is actually classified as a nonviolent crime in the state of Maryland, for which the maximum sentence is 10 years. And you only have to serve 25% of that if you get out on good time or diminution credits or parole. And so he would have served about 2.5 years if the jury understood what was going on. They clearly did not, because they acquitted him of first-degree murder and found him guilty of first-degree child abuse. I personally believe it's because first-degree child abuse was just the bottom of the verdict sheet and they thought it was a lesser crime. But it's not, and he got 45 years for that, plus the 10 on top of it. And so even with good time on the 45, he's got to do half of it. So 22.5 plus that 2.5. So he's going to do 25 years in jail. And he's been in 9, I think, now. Never gotten in trouble once. Maintained his innocence the entire time. Model inmate. Open cell door policy. And by the way, that's how all the clients that I believe are innocent act in jail. No one ever gets in trouble. It's kind of counterintuitive to think you wouldn't at some point get so frustrated with the fact that you are the only person who knows you didn't do it. But they don't. They patiently wait, and I think it's because we all grow up and we have to. I don't think any of us can live in this world and not believe that type of a wrong is going to be righted at some point. And sadly, it's not. And those of us that do this know that sometimes it's not.
And that's why those of us that do this need help.
Well, that's exactly right. And that's why we need these things. That we need the community of defense attorneys and professionals, the support staff, everyone that is ever going to be involved in any of these cases to know everything up front. My God, Monday morning quarterbacking shaken baby cases is so easy. And that's coming from someone who's tried them. And I know people are going to Monday morning quarterback my performance in the future. And there's so much you don't know and so much about the medical testimony that evolves over the trial. And it's hard. You know, the last case that I did, I ultimately wasn't allowed to use an expert witness that flew in from Portland, Oregon, because the court made a ruling about not having amended my actual paper document expert designation to include medical theories that my expert developed during trial watching the state's experts testify. I mean, obviously everybody's on notice of what those are because they happened during the trial. So apparently in this case, I was supposed to file. And so, you know, getting the defense experts, having them unable to testify for a variety of different reasons is very important. A little trick for those of you that are doing these cases. So one of the big issues I see in appeals of shaken baby cases is that the appellate court doesn't have a record of what the defense expert was going to say, and thus they don't have a record of an alternative cause of the child's death. And so they can't rule on a lot of appellate issues for that reason. They need to send it back for a hearing or, you know, and I see that in a lot of cases, that the appellate situation is detrimental to the defendant or the appellant because of a lack of a defense expert testifying. And I just told you that's happened in my cases. Well, have your defense expert handwrite their whole opinion, which, by the way, is fun because you think lawyers like to hear themselves speak. let a defense expert really just go on in handwriting. I think the last one I had was 72 handwritten pages. And then put that as a part of your sentencing memorandum and enter it in the record at sentencing. So the state's got their conviction, right? They're pretty much happy with that. They're not going to object to much at your sentencing. And that's actually how I just got that in the last case, too. They just didn't object in time, and it ended up becoming a part of the record in the case. And why is that important? It's important because then it can become a part of your record extract for your appellate brief. And believe me when I tell you, it's important to be able to keep pointing back in your appellate brief to your expert's opinion. And when it's handwritten there as part of the record, they can flip through it and read it themselves. And specifically, that's another very important fact. We all talk about reasonable doubt. We talk about the defense being able to just shoot holes in the state's theory, and the state has to prove it beyond a reasonable doubt. But I got to tell you, with a ton of jury trial experience, juries want to know what happened. They want an alternative theory. If you don't have one and it doesn't make a lot of sense, juries are not going to find people not guilty. Now, the problem with that is two of the biggest criminal defense cases in the world are the opposite of what I just said, O.J. Simpson and Casey Anthony. Both cases where I don't think there was a legitimate alternate theory, but the jury just really believed in that the state needs to prove its case in those cases. But that's not typical, and in Shaken Baby cases, the jury needs to know an alternative theory. They need to have another doctor. My God, do juries revere doctors. 2 letters after your name, folks. Walk on water, anything you say goes. So as it stands right now, Shaken Baby syndrome, the science is real science. And I just got a great question about, let me go there. The interrogation process. Another one of the problems that I've learned in these cases is that medical professionals testify that they're trained that if someone's story about what happened starts changing, red flags need to go up for abuse. The police, over and over and over, in all of these cases testify, they started the investigation, they got suspicious, they got warrants for things, all because someone's story changed. And I just do a factual example. So you wake up in the morning at, 6 a.m. and you go check on your baby, and your baby's not breathing, a little cold, something's wrong. You call 911. Okay, the next 10 or 15 minutes of your life are literally trying to learn baby CPR on your own child. You have no idea. You woke up and the child wasn't breathing. And about 10 or 15 minutes into the call, a million different facts. The paramedics show up soon after or before the police show up. Everyone's in your house. They sweep your baby off and take him to the emergency room. Oh, by the way, you've already been interrogated twice by EMTs before they even take the baby about what's going on, what happened, because they need information from you. So you don't remember those statements because you just gave them in a haze of awfulness and panic about your child, who you're just trying to get them to take to the hospital. And you're telling these people, look, I just woke up, nothing, I don't know what happened. And they keep being like, no, something had to happen. What happened? Nothing happened, I swear, So you've already had 2 interviews with officials, and then a police officer sits down with you and says, well, let me find out what happened. But you're clearly 3 minutes into that conversation, an anxious wreck about getting to the hospital. So the police officer says, you know what, we won't finish this statement. Go to the hospital. We'll do it there. Then you go to the hospital, and of course, you're questioned by a detective before you're allowed to go into the room to see the child. And then during that conversation with that detective, which is down the hall and around the corner, another detective, the one from the house that you were talking to, he shows up, and he found a bloody, handkerchief or something in your house, and he's up in your face with it. What's this? You didn't tell me about this. Are you telling me in those 7 statements over the course of that stressful 35 minutes, you're not going to say one thing in the English language that could be misinterpreted by someone? I mean, you're going to. You're going to. And folks, I just articulated to you the whole reason why the framers of our Constitution gave us a right to remain silent. Shut up. Don't talk to anybody. Don't give statements to police. Not because the police suck and we don't like them. That's not it. But it's because we're human beings. There's a lot of emotion involved. And the English language is the most imperfect way to communicate I can possibly think of. The day that we can start telepathically communicating, then I want you to talk to the police. Otherwise, people do not know what you're saying, and in stressful moments, you're going to say stupid things. So the amount of these cases that hinge on inconsistent statements, even the doctors testifying now, well, we're trained, the story changed, and I think the story started changing to try to fit some facts, So this interrogation stuff is real, and you hear a lot now, I think, about dream confessions. And they're not dream confessions in shaken baby cases. Dream confessions are where a 19-year-old with 110 IQ, hold on, let me. So somebody asked a question about new stuff and an appeal. So it's a really good question, because typically to get a new trial in some type of appellate or post-conviction stage, you don't just need new evidence. You need new evidence that couldn't have been discovered when you had your original trial. So that's the key. Now, for purposes of post-conviction relief, appellate relief, here's where new evidence matters. Back in that case I was talking about in 2006, I actually handled the post-conviction relief in that case, and I remember reading in 1 or 2 federal cases at the time about the actual innocence rule. And at the time it was not well-defined law at all. It now is. And essentially the actual innocence rule allows you to go to a federal post-conviction court, file a writ of habeas corpus motion, and if you can prove by a preponderance of evidence that you are actually innocent of the crime for which you were convicted, that's a way you can get a new trial now. It used to be the only way to get a new trial is showing your counsel was ineffective, there was juror misconduct, there was judicial misconduct, prosecutorial misconduct. That's my favorite one, because it's almost impossible that they gave you everything. And so those are typically the ways to get a new trial. But actual innocence gives a whole new way. So, for example, back in the late 90s and early 2000s, they did a bunch of legislation to reopen cases based on new DNA evidence. Maryland's a good example. If you have new DNA evidence, you are going to get a new trial in Maryland, period. If you do not have new DNA evidence, but you have 600 people all signing affidavits, you might not. And that's just the way it works. So the actual innocence rule is sort of a catch-all that even if all the state courts screwed up, you were wrongfully convicted at trial, the state appellate court rejected your appeal, and you lose your post-conviction relief, you still have other options. And it's going to federal court and saying, I'm actually innocent. Now, why am I talking about all this? Because you just asked, where does new evidence come in? I would say new evidence comes in most readily at that actual innocence effort. Now, you have to exhaust all of your other appellate and post-conviction remedies before you can get there, but you can argue actual innocence. You can argue it in every stage. In the appellate stage, I argue actual innocence essentially by arguing that no reasonable juror, given the facts of the case and the record at trial, could have convicted the defendant. And that's an appellate argument. And so I sort of backdoor in the actual innocence argument by saying, well, he was actually innocent. No juror could have found him guilty. That's usually a loser in appellate court because we give a lot of deference to juries. In post-conviction, which is in the trial court, going back to the trial court, on issues that require some type of a hearing or someone to explain something, like why a defense attorney did or didn't do something. During that hearing, you can actually show actual innocence. You may not have a state judge that's super knowledgeable about the actual innocence rule or willing to take the step that it takes to say I'm going to rule and give him a new trial based on the actual innocence rule. But you can definitely argue it in the state post-conviction, and then you're able to file your federal writ of habeas corpus. And in the habeas relief, you definitely, that's where it is defined case law. In a lot of these cases, that's what they're doing right now. That's ultimately how, what's the guy from where you grew up, Elif? No.
Missouri?
Yeah. The guy that was wrongfully convicted in Missouri, and Zellner just got him out. My girl, Kathleen Zellner. Sorry, I'm going to blow so much smoke up her. I mean, she is... Ryan. Yeah, we can't remember his name now, but the gentleman from Missouri who was wrongfully convicted of beating some man to death in a parking lot, he ultimately got out on the actual innocence rule. And there's a lot of these cases that these people do get out of jail, the shaken baby cases. You've probably seen them in the news and all. And that illustrates a point that I do want to make about these cases and why does old Shoemaker really care that much if maybe 1 or 2 of these guys did kill their baby. Here's why. All right, I've been doing this long enough to know what people act like after they're convicted, even the ones that keep yelling and screaming about their innocence the whole time. So I gave a stat on the Facebook page today, and it's a hard stat, so it could be off plus or minus 800, I don't know. But there's about 2,500 people in jail right now, convicted for killing their children based on medical science of shaken baby syndrome, all of whom continue to maintain their innocence since the date of their conviction, some of them 20, 25 years later. Now, the reason that's so important is, number one, most people don't do that. Most people that say that they're innocent ultimately acknowledge their guilt at some point during their incarceration. And why do they do that? They do that because they sit in front of a parole commission board, a clemency hearing board, some group of people that is not designed to say you were innocent, but is designed to say, we're going to grant you parole or clemency because you're finally acknowledging what you did, that it was a mistake, and that you need to suffer the consequences from it. So if you're sitting there in front of a parole board and saying, and the parole board is talking to you, and can you just admit you did it? Well, you know what? We'll let you out tomorrow if you admit you did it. You know, or let's say a prosecutor comes to you. This happened in that, God, I can't remember the names of any of these cases now. One down south where they knew they were going to lose it on appeal and post-conviction, so they went to the defendant who was incarcerated and they said, we will let you revise your conviction, we'll vacate it, and you enter an Alford plea to guilt, and we'll give you time served. An Alford plea is where you don't say I did it, but you say I acknowledge that the state has enough evidence to convict me. That's what I mean about the English language. Those of you who aren't attorneys out there hopefully just heard what I said and was like, he said the same thing. An Alford plea is, I didn't do it, but I acknowledge the state can prove I did it. And why do they do that? They do that because you're going to get out of jail, but guess what? You ain't going to sue them for what they did wrong because you've now acknowledged guilt. Hold on.
Where can you look up actual innocence rule? And it's Ryan Ferguson.
Yeah, so Ryan Ferguson, there you go. I know we get some of these names. Got my fact checkers here. Yeah, right. Actual innocence rule, I believe there's a Wikipedia page for it now. But you know, you can do it on any of the good legal research sites. I could say Lexis and Westlaw, but that's because I'm a law school child of the early 2000s. Google Scholar. If you Google Scholar and go to Google Scholar, you can pick your state, and you can literally, it'll give you a little search box for case law. So pick any federal circuit, any federal district, pick the whole country, it doesn't matter, and just type into the Google search box, in quotes, actual innocence rule, because you've put it in quotes and it has to say actual innocence rule altogether like that. This is like a whole year of law school. You can put /s between words, and that means those two words in the same sentence, /p, same paragraph. It's a whole different webinar. So, yeah, those of you who want to find out more about the actual innocence rule, sadly, I would say Google it. If you type it into Google, you're probably going to get as much information. In Wikipedia, that they always have the case sites. You know, in 2017, anybody going back to the legal books, I've got some in my office, but we just take pictures in front of them. Nobody actually ever opens them up and reads them or anything. Now, I was talking about the problem with confessions. I was talking about where you use this new, no more Lexis, Google. That's right, Mac. Unfortunately, despite that I know I'm giving all my information to Google. Yeah. As a matter of fact, Danny, what did we read today? We were setting up my son's new Google phone, and it said something about, in bold, help us improve your Android experience, in bold. And just a little checkbox to check, right? You know, of course, yeah, absolutely. And then in smaller font, not in bold underneath it, it said, by sending us all of your information. And so we've been talking about the difference between Google and Apple and who mines your information and who doesn't. I digress.
Talk about the interrogation process.
Yeah, just did. So yeah, we were in the process of talking about the interrogation process.
When you remember more and more, like,
right? No, I just made a statement that in Shaken Baby cases they're not dream confessions. That's what I wanted to explain. So they're not. Dream confessions are where a police officer brings a I don't know, a 17-year-old or 19-year-old with mental health issues and a 95 IQ in, and feeds him or her a bunch of information, and then makes him or her feel like the only way that they will leave that room and go home is by admitting or saying or confessing to the information that they've just fed them. And then the person comes up with a dream confession, after which, of course, they don't go home, they're arrested. That's a dream confession. Shaken Baby cases are not that. Shaken Baby cases are concerned, freaked out, panic-stricken parents being interrogated by police officers and actually trying to make an effort at figuring out what in the world happened to their baby. And that's what everybody else in these cases forgets, that investigates them and prosecutes them and everything else. These people just had a baby die and they don't know what happened. And so what happens through the course of an interrogation is you start talking about things that could have, oh my God, you know what? I do remember the kid bumped his head on the bathtub the night before. You know, how hard did they bump that? You know, and then the bump on the head in the bath, it becomes a trial issue. So all of these things that in regular, normal, everyday life would not be issues in child rearing, all of a sudden become issues now. the things that they characterize as past evidence of abuse are not past evidence of abuse. It's bad. And again, the reason why is where the medical science is. I talked about the originator, the inventor of shaken baby syndrome, doesn't believe in it anymore. And he's appalled by the way it's used by the state to convict people over and over. So you automatically think, well, of course, doctors don't believe this crap anymore. And that's the problem. It is still the prevailing consensus medical theory, even in today's world, where I believe in the spring of 2015, the Washington Post did a 6-day, 40-page, I might be exaggerating, but a long project called The Shaken Science of Shaken Baby. And that's all it kept articulating, is how all these holes keep getting shot in it. But the medical community, and especially folks, the pediatric community, I'm sorry for all my pediatrician friends. I don't really have that many pediatrician friends. But I am sorry for saying this, but based on my personal interaction with the pediatric community, both professionally and with my own kids, they are a group of children themselves when it comes to believing and just towing the line of whatever the American Academy of Pediatrics says. By the way, the American Academy of Pediatrics, they're the ones that changed the name from shaken baby syndrome to non-accidental head trauma. I think it was abusive head trauma at some point in the middle, but essentially they're just trying to soften the oomph of it, because shaken baby syndrome, what do you think of? You obviously think of somebody shaking a baby. But what they're saying is this triad of symptoms can show up by some type of abuse. We don't know what it is. We know it can happen by throwing a baby softly up and down on a bed 50 times, but we don't think that's what happened. Something like that involved rage. This is what I mean, guys. So the science is still the prevailing medical theory. And the way you would typically defeat a medical theory is at a Fry hearing. You would have a hearing before your trial, for those of you that aren't lawyers, and everyone would testify, all these expert witnesses, and the judge would make a determination as to which experts are allowed to testify at the trial. And the experts that are allowed to testify at the trial are the experts that have shown the judge that their theory is based on knowledge that they've acquired as part that other professionals believe it, that it's written in books, it's written about, and everyone agrees that it exists. So that's how Shaken Baby has become a theory on which thousands of people have been thrown in jail, is because everybody just ran with it. The problem is we started with the conclusion. We got a dead baby with a triad of symptoms that we can't explain. And that's where we started. And then we decided it was abuse. And since that moment, we've just, the entire time, been trying to throw Band-Aids over all of these problems with the science. And until someone wins one of these hearings in a case where a state judge says it's not the prevailing science anymore, I rule that now 51% of pediatric experts, child abuse experts, do not believe Shaken Baby exists, because there are a group of them out there. And I'm going to get into that here in a couple of minutes about how we fix this problem, because there are a group of freaking heroes, hero doctors. And here's why I say that. We all hear about medical insurance and everything else, but come on, nobody's crying for the thoracic surgeon down the street that had to turn his Maserati in and drive a Lexus. And the problem with that is doctors aren't going to step outside of what is the prevailing medical consensus very often, because they get paid to be a part of the medical consensus. You certainly don't want to piss off the American Academy of Pediatrics if you want to be a pediatrician, right? And so there's a lot of this sort of towing the line thing going on. But these doctors, these expert witnesses, and I'm going to post on my page later the names. There's 4 or 5 of these guys that have, and I mean this when I say it, given up their entire reputation in the medical profession, probably cost them mucho dinero to come and testify in these cases for very low money, if any at all. But their incomes, I mean, imagine trying to run a practice when the American Academy of Pediatrics hates you. I mean, licensing issues, it's insane. Threats, and these guys keep testifying. And they've done so at the expense of proverbially, bashing their heads into a wall of unreasonableness, lack of logic. It's insane, and it has to be so frustrating. I've been through it twice, and it is. It's extraordinarily frustrating. And these guys know, right? They know what we know, which is whether it's biomechanics or whether it's medical science. The reality with shaken baby syndrome is we don't know what killed a lot of these kids. If you really sit down and do the work, you can figure it out in most of the cases. And here's what I mean. It's not as cut dry as everyone thinks. When you review medical records, let's say you have a 2-month-old baby that ended up dead. You've got birth records. You've got the first few months of pediatric records. Then you've got all the emergency room records and the medevac records and all the things that happened the day the child died, because they probably flew the child back and forth between a bunch of hospitals trying to save him. And so that's a lot of records, all of which contain some information that may or may not be relevant. One thing that we know is relevant to shaken baby cases is head size. Okay, so remember my first illustration of the wet rag, right? So imagine you're an infant and you have the typical brain of a child, and so you have the brain and the wet rag and then your skull. If your head grows fast, right, it's going to stretch out all the little blood vessels that connect that wet rag to your brain, right? So as you stretch those all out because the head is expanding, I don't know. This is just my layperson theory. It's not. I've heard this from at least 5 defense experts. As it stretches those blood vessels and capillaries out, it becomes that much easier to flick a kid in the head and cause subdural hematomas because they're all stretched out under there. So you could hit a child in the head in a way that doesn't cause a bruise or anything else, but busted a bunch of those blood vessels in between the wet rag and the brain, causing subdural hematomas. Now, that's easy to prove, right? No. I have done a case where, despite the following measurements, at birth, 40th percentile, right? So regular size head, less than regular size head, less than average. That's probably a better way to put that. 1 month into the child's life, 1 week into the child's life, 75th percentile. 1 month into the child's life, 88th percentile. And then about 2 weeks before the child died, when the child had a 60-day visit or so, 98th percentile. And then right before the child died, 99.98th percentile. Okay, let me get that. For all you mathematicians, 99.98 is not 1 in 100 that had it. It's not at all. 99.98 is an extraordinarily high, rapidly growing head. And in 2 months to go from 40th to 99.98th percentile, I consider that rapid enlargement of the head, rapid head growth. Now, in that case, not one single one of the state's experts admitted that the child had a rapidly enlarging head. And that seems crazy, but here's why. The birth record was 40th percentile, okay? The pediatric records went from 77th or whatever to 99th percentile. And then that last record was at the emergency room the day the child died, that 99.98 one. So all the OBGYNs that had the birth said, well, the kid had a normal size head. And then the pediatrician said, well, yeah, the kid had a large head, but it wasn't rapidly enlarging. It was already large when he got here. It was 75th percentile, 77th percentile. And it only ended at 98th percentile. So 2 out of 100 kids had bigger heads than him. And then the forensic pathologist didn't really care. As a matter of fact, didn't even measure the head. But I think in that case did suggest that perhaps the measurements could have been wrong. How could they be bigger? I agree you could get the measurement wrong, because you have to measure the largest circumference point of the head. So you could arguably measure a smaller point. But how could you possibly get a larger measurement? The kid had a helmet on? Anyway, you see the point. In that case, because the pediatrician didn't know the birth records were started at 40th percentile and didn't have that last reading, there was not one doctor that had a comprehensive set of those measurements and information. And then, of course, once they testify for the state that the child does not have a large head, which is called macrocephalic, by the way, if they testify that the child is not macrocephalic, then they certainly, during cross-examination, when you slap that 40th percentile down in front of them, and we all know that's the definition of macrocephaly, but they're not going to back down now. In front of a jury, they're not going to admit to some spiky-haired lawyer with tattoos on his wrists that, nope, they were mistaken. You're right, counsel. They're just not going to, whether it's because of ego or maybe they think he really did it. I don't know what it is, but they're not going to admit to it at that point. And so they'll say something like, it's a 2-month-old child. You know, really, that's too early to diagnose anything like macrocephaly, right? Or no, one of the other theories, they'll say things like, well, the child wasn't exhibiting any developmental delays, and that would be evidence of this other thing that organically. The child was 2 months old. How could you possibly see developmental delays in a 2-month-old child? I don't know, guys. So this is what happens. You get tunnel vision, a whole set of professionals involved. You know, the prosecutors obviously believe that shaken baby exists. But I'm telling you, these people, it's not going to take much for the whole domino effect to happen. One of the last trials I did during closing, the prosecutor stood up at closing and made this whole argument that despite the conviction for first degree intentional child abuse that resulted in the death of an infant, stood up and kept talking about he didn't really, they know he didn't mean to do it and he's not a monster and you know, but that's not what the conviction was for. The conviction was for an intentional killing of a child. So I stood there listening to that and realizing that the reason that dichotomy is coming out in closing argument is because they are worried that the jurors, nobody can say how it happened, and God, it really doesn't. He just kind of sat there and whimpered the whole trial, which is another thing that innocent defendants, they act way different, the guys that are sitting through this process and know that they're innocent. It's hard to describe because there's just a level of, like, I know the whole trial they're just hearing bzzz. It's absolutely one of the most gut-wrenching things in the world to sit next to someone that you know did not do something like kill a baby and have them accused of it. In any event, that's why people stop doing it. That's why, I mean, most smart lawyers, after they lose one of them, are like, nope, not going to do this anymore. That's also why we need to stop doing that. You don't want the 10 best oncologists in the world deciding that because cancer's kind of crappy and a pain in the butt, they don't want to deal with it anymore and they're going to go play golf because we want to cure cancer. And I'm telling you guys, this shaken baby syndrome issue is one of the biggest issues in our criminal justice system today. We tout our justice system as the best in the world, and I do believe it is. But we have to follow that up with every justice system has a ton of problems, and ours does too. It is the best in the world, but it can be a lot better. And when we know it can be better and we can make the changes, we need to do it. I gave the examples before of the death penalty. My very young and naive attorney that I was 10, 15 years ago, I was a huge proponent of the death penalty. And now I have seen, read about wrongful convictions. People, no. Until you have a criminal justice system that is 100%, you can't even get to the argument of whether the death penalty works. By the way, it doesn't. Neither does harsh jail conditions. Proven facts. Maryland did a commission by 2012, 2013. They came back saying two things. Number one, there are racial and geographic disparities in the way people are sentenced in Maryland. Yeah, out loud, in writing. And number two, harsh punishments, harsh jail conditions, and the deterrent effect do not prevent recidivism, and in fact, in some cases, actually have more recidivism because of it. So we know that those aren't working. But the importance of this is we are guessing people into the penitentiary and labeling them as baby killers, right? And that's a term that it's God, man, you can become a little bit sociopathic when you do some of this stuff for a living. I'm realizing as I'm about to tell this story how bad it really is. But so the first case that I did that was a shaken baby case was in a real small jurisdiction in Maryland, and the television channel, the local TV channel there, had me on the news, and I was young, and I was, yeah, great, I did an interview. It was cool. I'm gonna be on the news tonight, right? My grandparents lived in this little town. And so the next day on the news, it pops up, and it's my face, and it's all awesome, and it says, Jason W. Shoemaker, baby killer's attorney. And for anybody that knows me in the courthouse where I work, there were, I'm not sure if any of them are there anymore, but there were a group of clerks that used to, again, a little sociopathically, call me BKA because of that little news thing where I was labeled by the news in that county as baby killer's attorney. So that label is no joke. Forgetting about all the obvious things, like you're not going to get a job or even be able to take your kid to a Little League game, you know, when you get out, because there's going to be a little note in every DSS file in every county that you really can't be around kids because you killed a baby. And while you're incarcerated, that's not something that you want to come out. It's 2017, folks. It's hard to prevent people from knowing what you did, because as soon as they're on the phone with someone on the outside, hey, can you Google whatever? And so that's tough, because, I mean, you better convince that whole facility that you're innocent before you let anybody know why you're in there, or you do become the target of all kinds of things. You know, when a gang member is trying to be initiated and has to do something to someone to do so, you think they're going to they're going to choose child pornographers, baby killers. We all know that these things happen. So that makes those of us that have been involved in these cases lose even more sleep thinking about that. I just had a client who was at again, as far as jails go, not a horrible facility. He was in a facility around where his whole family was. They visited him daily. They had like 24 visitors a day. His child, his baby, is a good example because he was convicted of killing this shaken baby case. I think he's got to be supervised around his own kid for the next 10. It's so ridiculous. Anyway, when we filed the appeal, 2 or 3 days after we filed an appellate's brief, and I think this is a coincidence, I do, but I have never understood how you explain that to a client. 2 days after we file our appellate brief, in the middle of the night, they come in his cell, put him on a bus, move him 3.5 hours to the eastern shore of Maryland to a facility called ECI, which is a way different facility. The one he was at was sort of a last 10 years or less, and everybody's training to do jobs and all, to Eastern Correctional Institute, which is, it's called medium security, but that's all bullshit too. Maximum security is really what it is. Maryland doesn't even have any technically maximum security facilities except for a federal one in Cumberland. But it's not a friendly place. It's 3.5 hours from all the visitors that I was just talking about. It's 3.5 hours from his lawyer, who likes to meet with his client to, go through appellate stuff and all. And like I said, I do think that was a coincidence. I don't think it should have happened. And I do think it's sometimes for all the wrong reasons. So going through the appellate process is not the focus of this webinar. Fixing the problem is the focus of this webinar, and we don't have a lot of time left, so I want to get into fixing the problem. We can appeal these cases, and we can let Barry Scheck and his crew, the Innocence Project folks, literally tear the heads off every investigator and doctor that's ever testified for the state. That's not going to fix the problem. Until somebody wins a Fry Reed hearing, until somebody has a judge or an appellate court say this is no longer good science, the only way this problem is going to get fixed is by prosecutors exercising discretion. Now, it's so easy, right? And if you look around the country, I tried to get this stat, and it is such a, it's a difficult stat to get, as most stats are, but how many prosecutors in how many jurisdictions over the country are doing just that? Because they're out there. There are many jurisdictions in this country that they do not, if a certain set of facts are there, and specifically I'm talking about subdural hematomas and evidence of no other damage, not a finger mark, not a neck injury, nothing, that they're not prosecuting those cases anymore. Even though they have witnesses lined up and they could get convictions, 98% or whatever, they're choosing not to prosecute them. That's why it's such a telling exercise in discretion. When you got 98% conviction rates and you're choosing not to prosecute a case that you can win, that's a real exercise in prosecutorial discretion. So that's how we're eliminating the problem, because the medical industry is not going to get there before prosecutors do. And prosecutors are subject to political liability. Stop electing them. Jeez. If they're not going to do the right thing, stop electing them. So prosecutorial discretion is the number one way that this is going to get fixed. And then the number two way that this is going to get fixed is, I don't know how we do it, a GoFundMe page. But yeah, Leaf, can you get me like a quick, somebody's got to know the names, the doctors. I want to list the doctors on the Facebook page, and I want to say their names, but we need to put together some type of fund. Maybe someone watching this webinar is a billionaire and they want to give an anonymous donation to pay these doctors, people, pay them to go to these trials, pay them to feed their children, pay them to live their lives standing up and saying, we know that this doesn't exist. Because the problem I see with them is eventually a lot of these experts are going to have to quit because you have to put food on your table. You can't go from a standard of living as a doctor with his own practice to unemployed. It's too big of a jump, and if all you have to do is give up testifying about one topic, I mean, I'm not gonna say I wouldn't do that for my 2 kids. So when these guys, and again I'm getting the names here, but when these guys are consistently going state to state and testifying and being cross-examined by these prosecutors for 2 days at a time, and then when they leave, just being completely just ostracized from the entire medical community, it's a difficult situation. So that's the number 2 way that we can fix things, is making sure that these guys are literally heralded the way that they should. I mean, they're absolute heroes. I don't know that they go around doing cases for free. But I know they post every time, and some of them have some wins under their belt.
Dr.
Some of them have
Amy
some.
Squire says shaken baby syndrome does not exist.
Well, yeah, there's so I'm gonna put the list of the doctors on the Facebook page here in about 5 or 10 minutes. But yeah, we of course Google doctors against shaken baby syndrome. No, I mean I can Dr. Robert Chabon in Portland, Oregon. These are all guys who a lot of them were big proponents of it and testified and convicted some people in the 80s and 90s, and then because they studied it for so long. It's not even came to the realization. They all come to the realization pretty soon that this science is nonsense. It's when do they have the strength and courage to stand up and say it. And bravo to all the doctors that have. Because I don't know a single one of them that it wasn't some type of life-altering event for them to do that. I mean, it's not even fun to come and testify for the defense. You don't get spit on or anything in the courtroom, but people don't say nice things about you, especially other doctors. So look, this is a huge topic, guys. In fact, I mean, I could probably talk for another 4 hours about it. Anybody that wants to email questions about shaken baby, anybody that has concerns about their case.
Before you log off, just
I'm
stick
just
on the
talking.
appeal part
I did appeals.
of,
Yeah, I did appeals for a while. Jason at Shoemaker Law LLC.com. All one word. ShoemakerLawLLC.com. Send me an email with the questions. You can also email Elif, E-L-I-F, at Shoemaker Law, or Ben, B-E-N, at Shoemaker Law. ShoemakerLawLLC.com. Send me emails, questions, concerns. I mean, there are Facebook pages. The Syndrome was a movie that came out recently, a documentary. The group that did that, all these doctors that I'm talking about are in it. What's the Facebook page's name? I mean, the Innocence Project, obviously. I'll pimp them out all day. In fact, that 2006 case that I talked about a little bit, the Innocence Project, I understand. I don't think they've taken it yet, but I think it's in whatever pipeline to get to them, and that's exciting stuff. And I'm saying that even though I'm the defense lawyer that will end up being the possible reason he gets out of jail for not giving him effective assistance of counsel. I don't care. I'd fall on that sword if I could, but obviously they don't let the lawyer come back in and do that because he wants his client out of jail. But the reality is, if you can get the Innocence Project involved, that's the real deal. And that's another way to fix this and a lot of other problems. The Innocence Project should not have to be independently funded or pro bono. It shouldn't. We should be dumping millions, if not billions, into the defense bar. Because, folks, that is it is the only thing between you and the jackboots kicking your door down. And I'm not joking. You look in other countries, I've said this before on these webinars, the difference between our system and the way defense attorneys are in this country and the fact that most of us say we will represent the worst of the worst because everybody gets a defense. That's why. In most countries, you could be locked up, arrested, sit in a jail cell for 8 months before someone comes in one day, picks you up, brushes you off, and says, have a good day. And they don't have to tell you why you were there, what you were charged with, what you were alleged to have done. Nothing. And you just have to go on your merry way because 8 months being in a hole in some South American country is probably not detrimental to your life. That will never happen in this country. There will be bad things that happen here. But because the defense bar is strong, and I've witnessed this, I have practiced in jurisdictions like Washington, D.C., where, I mean, the defense bar is very strong, very, very strong, and the prosecutors are overworked. And I've worked in jurisdictions like the one I'm currently in, where, I mean, it's been years and years and years of just the defense bar being beat down by judges that keep giving exactly what prosecutors want. And there's maybe an argument that cleans places up and everything else, but it's changing now. Once a whole generation of the judiciary is mandatorily retired and you get a whole bunch of new judges in and they start thinking a little bit differently. That's why this hot button issue of shaken baby needs to be hit on now. Look, the cookie is crumbling. Google it tonight. I tried to get another stat of how many states there are right now where the highest court in the state has thrown out at least one shaken baby case. I mean, it's got to be close to half of the states in this country at this point that for some reason these high courts have thrown out these shaken baby cases. I've got one on appeal right now, but because the Fry Reed hearing never happened and that the medical science wasn't challenged, if I win the appeal, it'll be on other issues. And that's one I am going to talk about when I hit on before, the cell phone issue and the seizure of cell phones and when the police can do that to hold on to them to get a warrant and search them. Whole different issue. I'm going to put the list of these doctors' names. I actually sent an email to a couple of them that we do communicate with and ask if there's any contact information that I can give out for anybody who contacts me and says they're going through this. There's Facebook pages that we will be pimping out on the Shoemaker Law page here tonight that you can go to. And obviously, if you end up being accepted as a member of them, it's a whole community of people going through this. And for any of you who are going through any type of accusation involving the abuse of your child, please, please, please reach out for help, especially if you have other children. They've probably been taken from you. This whole innocent until proven guilty probably doesn't exactly seem like that's what it feels like if you're being accused of something involving a child. And that really is what happened. My last client that went through this was had a great job at a elementary school, the public school system, benefits, a great pension. Obviously, the mere accusation alone, even if we had exonerated him at his trial, I'm not sure he would have walked back in there. So, yes, it's important to reach out for help. It's important to know that there is a support network out there. It's important to have somewhere to go vent when the newspaper calls you a baby killer. Because I got to tell you, in a lot of serious cases that I've done, newspaper-worthy cases, that first article about what happened, the one that is rife with the most factual errors because it's based on what everybody saw that first night, that's the big one, right? That article about the acquittal or the person that admitted that he didn't do it, or, I mean, if it's there, that's not the top full front page article because it's not quite as sexy. It's not going to sell as many newspapers. Again, I'm not blaming any of these groups of people, and I said that at the beginning. I'm going to say it again. It's how all these things fit together in this science of shaken baby, which I didn't even say what the actual beginning of it was. Shaken baby syndrome was really originally designed to explain why children in car seats, like all tucked in, that got into car accidents ended up with this triad of symptoms. And that makes sense to me. You strap a kid's neck and head in, he might not have neck injuries, but he might have enough whipping around to do subdural hematomas. That's a factual situation. That's not an abuse case. And that's how that theory originally developed. And like I said, it caught hold. I mean, folks, what the first group of cases, and this is, again, the syndrome, I'm going to give you links to all of this whenever if I stop talking tonight, I'm going to give you links to all of this stuff. But one of the things the syndrome talks about is, believe it or not, two of the biggest shaken baby nutcase proponent doctors out there are two of the same doctors that were part of the group of doctors that were testifying as experts in the 80s about these cases that involved children that died, and their theory was they died as a part of satanic cults and cult rituals. And there was all this expert testimony and hocus pocus expert medical testimony about the evidence that these children were killed as part of... Now, the good news is that one didn't take too long for everyone to figure out this is junk science and we ain't convicted people of this. So two out of that group of doctors, instead of slinking away into whatever hole they should have for doing that in the first place, became two of the leading proponents for shaken baby syndrome. And I've watched these people debate the hero doctors I'm talking about that testify for the defense. I've watched them debate all the way from 2005 when they had all the science and all the community on their side to recently when people are poking holes in the science. And really the biggest hole that can be poked in the science is the one I keep talking about, that neck injury thing. Say whatever you want about all the bleeding and everything else, but I mean, anybody that's had a two-month-old baby knows. I mean, you literally, the only thing you have to do other than feed and change a diaper of a 2-month-old is hold its head up, right? This kid hold his neck up. Now, this boy though, I think my son was like 11 pounds when he was born. He could probably hold his head up when he was like a week old, but most 2-month-old babies. So this idea of somehow abusing or rage killing an infant with a head situation like that, you would have to concoct some brace before you did. I mean, it's just almost inconceivable. But the problem is that's not a medical theory. That's a biomechanical engineering theory. Specifically, the theory is that the amount of force necessary to cause the inside of a baby's brain to bleed is less than the amount of force necessary to cause neck injuries to an infant. I think it's significantly less. But another tip for you defense attorneys or anybody going through this, experts. I mean, obviously we got money situations. That's why I'm saying I'm hoping we can somehow get something together where people who are independently wealthy can pay for some of these experts and all. But you need a biomechanical engineer and you need a child abuse expert, a pediatrician. And the biomechanical engineer you need because no matter how much you object and turn blue and dance on the trial table, they're going to let the state's experts refute your biomechanical engineering defenses. And that's going to be a defense. You're going to keep asking everybody how in the world this child didn't have a finger mark on him, right? No. Didn't have a bruise. No. Not a single neck injury. Nothing. How in the world, if you put enough force on a baby to make its brain bleed, could there possibly be nothing else? Doesn't this have to be something we don't know about, you know? And that theory will be refuted by the pathologists and it'll be refuted by the pediatricians and they shouldn't be allowed to refute it. It should have to be a biomechanical engineer that comes in and refutes that theory because the doctor can't tell me the force necessary. And the reality is nobody really can, and that's what they get away with. Well, those studies aren't exactly perfect. Well, yeah, of course they're not perfect because you're not allowed to shake live babies, right? So they have to do the studies on, crash test dummies or, I was going to say live monkeys. I do think there was a study where they might have done it to monkey babies, though. And that's got to be getting close. But, I'm not suggesting any live study of shaking real babies is worthwhile. I'm suggesting that we now have the technology to do pretty much anything in the world that we want to do to any type of natural resource in the world that we want to do. You're telling me that we don't have the technology to figure it's easy. It's laziness. It's not incompetence. It's not malice. It's not even greed. It's just going with the flow. And again, the prosecutors that's the first step in the process. Police officer comes with charges. Hi, Mr. Prosecutor, we would like to file an application for statement of charges against so-and-so for first-degree child abuse. Stop. I want to see all the medical records. I want to see the birth records. I want to see the pediatric records. I want to see the pathology records, the autopsy report. I want them all on my desk. And I want 2 doctors that have testified for the state before to sit here in this conference room with me and go through this for the next couple of days until we come to the conclusion that there is no alternative cause of this child's death. And then I'll prosecute the case. Otherwise, these are prosecutors. It's beyond a reasonable doubt. You're putting people in jail. You're taking away their freedom. Go sue them for money. You think he's responsible for the death of your baby? 51%. Go sue him for money. Get a judgment against them. Maybe they pay 25% of their income on a garnishment the rest of their lives. I don't know. But you're not taking away their freedom. That's why it's got to be a discretionary issue. And that's why I don't care what anybody says. In any other context of law, with facts that weak, prosecutors aren't going to trial with it. But if there's a dead baby involved, they just got to keep hammering on that. I mean, you'd be amazed, people. The last trial that I did for this, the pictures they put up. What possible relevance does a picture involving a dissected skull of a child in an autopsy have with how that happened? It's ridiculous, but it's really shocking and awe-inspiring. And of course, then they accidentally leave the pictures up. In the last trial that I did, right in the middle of the trial, the state had, of course, left a picture of the child up with all these tubes coming in and out of his mouth. And the
jury.
Well, they over objection, the judge allowed the picture to stay up because it was being used to describe the way the child looked to the emergency room pediatrician when she first met him. Come on. So anyway, it stayed up. The jury sent out a note about 5 minutes later. That's it. Out of respect for the families, could someone please take that picture down? So, I do feel the cookie crumbling. I don't think it needs much more of a push over the edge to get to a point to where it's not a medical theory worthy of criminal court. Maybe it stays in civil court for a little bit longer. But if it is legitimate medical science, it is not beyond a reasonable doubt from a causation standard. Period. It's not. And so, look, pay these doctors that are going to come and testify. I'd give them all $1 million tonight if I had 2 nickels to rub together. I'd fly them out to every single case going on right now with Shaken Baby. I can list people we've spoken to in the last couple of weeks off of these websites. Baby, who's the group, the big website? She's got her headphones on, not listening now. Who's the big website, the big group that I need to pimp out a little bit?
You can't.
I can't read because you're, yeah. Oh,
Jason.
yeah.
What the?
Yeah.
Shaking baby false accusations is
Yeah, no, I know. And that's I told everybody that you have to you can't just, these aren't sites that you can just find for the obvious reason. People don't like individuals that stand up and say shaken baby doesn't exist. People are being wrongfully convicted by the state. I mean, I get it. That's what I do for a living, so I'm not quite as anonymous about it as some need to be. But I was just being cautioned that these sites are all anonymous, and they are. But they're out there, and that's what I'm talking about. People that are going through this, you need to seek those things out. That's why you can just send me an email. If you're someone going through this, then that works. Yeah, somebody just wrote that they used the fact that we paid experts against him at trial. That is a difficult thing. And again, defense bar, folks, that shouldn't have gotten halfway out of a prosecutor's mouth before someone was dancing on a table. Your Honor, are they about to say anything adversely commenting on the fact that we brought rebuttal experts? Because that's all defense experts are. They're going to give their theory and they're going to rebut whatever the state said. Rebut. So they're going to use everything against you at trial because it's adversarial. So they're going to couch everything in a light most favorable to the state. And again, that's prosecutors do that. They do that in every case. In fact, the good prosecutors are the ones that stand up in the relatively minor cases and talk about how you have to save the community from. I mean, those are the good defense attorneys are the ones that are over the top when it comes to the arguments phase of things. But that's how the system works, and that's not what the problem is with these cases. So, exercising discretion by prosecutors and getting these experts to get the word out. That's all this is about. But regardless of the anonymity of the websites or anything, if you're going through this right now and you're alone, email me. If I can't get you in touch with any of these other websites, we'll help support you. It is awful, people. It is awful going through it from the outskirts of it. I have had one incident in my life where the two families that were involved in the two cases that I did were in one room. And it involved the syndrome, that documentary I was talking about, and doing a showing of that. And I got to tell you, I cannot wrap my head around how any of them keep going on with what they know, with where their child, brother, significant other, child's father, whatever is. And every single one of them, I don't care if it's a 7-hour round trip, they post every time for visits. They bring whoever they need to bring. They're always there for support. And I mean, they're fortunate. I cannot imagine trying to go through this process, and people are. Just them and their spouse. It's very, very tough. So reach out, people. If you can't find anybody else out to reach out to old Shoemaker. All my information is on this site. Now, I'm going to go off here because it's been like an hour and 20 minutes. Wow. No, this is the idea, guys. I'd stay on here for another 6 hours if everybody was dialoguing about it. I'm going to put a lot of this information on the website tonight. I'm going to put these doctors' names. They don't care about being anonymous. The doctors, they're right. I'm obviously not going to put names of people on anonymous websites, but I want to put some of the information out there for these experts that are testifying for the defense and that I think have this figured out now.
Maybe create some sort of portal where everybody can,
Yeah, that's what
adding names and lists,
right.
And you can have.
That's right. That's right. Anonymous or not. And like I said, I'm not worried about the repercussions of it. I was labeled baby killer's attorney on the news in 2007, so I'm not worried about any of that stuff. So the reality is, if we could start some type of, even on the Shoemaker Law website, where it's just an ongoing list of the medical professionals that you could call, because that's tough. I remember the first case I did, I sent it to Thomson Reuters, which was a group that was owned by Thomson Reuters, and they were finding expert witnesses for attorneys. And of course, I didn't hang out with any child abuse pediatricians or anything at the time. So I sent an email to a friend of mine that I work with on some other cases and asked him to send me some experts that had that background. And that's how I got the name of the first one. But it's not easy to find. I mean, it's not. So that type of information, good attorneys. Look, you find a competent attorney with his head right on his shoulders and they learn what they need to learn before the trial, you're going to be fine. The problem is it's really hard to get that amount of information unless you really know what to look for. And it's a wide breadth in these cases. I mean, you literally, once you start with the premise that this guy didn't abuse his child to death, I got to tell you, the factual circumstances, the pathology, the subdural hematomas without any other injuries, it's a really difficult fact pattern to figure out. And I've spent hundreds, if not over 1,000 hours reviewing medical records, looking for that smoking gun. And I've got to tell you, I found it 5 or 6 times. Of course, it turns out not to be it. Either the abbreviation of the medical record was something different, or, but that's why it's so important to be knowledgeable before you go in, because once that trial starts, once those experts start testifying, you better know your words. You better know exactly what, or else they're gonna murder you when you're trying to cross-examine them. You got to learn all the language, all the verbiage. You throw back at some forensic pathologist something about how, whether or not the eye damage goes all the way to the ora serrata. You got to be knowledgeable about these things. And if you're a public defender with 54 cases going on that week, or if you're a low bono or pro bono attorney, or if you're just a regular attorney who has now spent 784 hours on the case, it's going to take a lot of your time. It's going to take a lot of your energy. It's going to ruin your stress levels. That's if you're a human being. Even those of us that are such huge narcissists that we became lawyers still have feelings, and it's tough to do. So fight through that. It does not help your client to throw a pity party. The family, believe me, will go through enough of that. But look, guys, if anybody needs help, any concerns, questions, criticisms, send them to me. Jason at ShoemakerLawLLC.com. Thank you all for listening to me babble for almost 80 minutes now. It's been fun. We'll do it again next week. Shoemaker out.